This week's DRM Not Included on F5 Live Refreshing Technology is proudly powered by Amazon Prime. We all know that you get free shipping on millions of products with Amazon Prime, but you get a whole lot more. Like free music with Amazon Prime Music, free TV, movies, and documentaries with Amazon Prime Video, free games, and a free Twitch subscription to support the content creator of your choice with Amazon Prime Gaming, plus a whole lot more. We've got links to all of these features and some of our favorites, plus a 30-day free trial, all by going to f5live.tv/prime. In the early days of generative AI, somebody by the name of Stephen Thaler, let's go with that, created a system called the Creativity Machine and used it to generate a piece of art which was entitled A Recent Entrant to Paradise. When this came out, Stephen tried to copyright it through the U.S. copyright system and was summarily denied, saying that the definition of an artist required that it be human. Stephen wasn't happy with that, filed suit against the Copyright Office, and has kind of been bounced up the appellate system, landed in the U.S. Court of Appeals for the District of Columbia Circuit, and a panel of 3 judges unanimously agreed with the Copyright Office. The decision stated that the definition does indeed require it be a human. There are certain stipulations about length of the life of a copyright and things like that that involve the life of the artist, which would not be possible with a machine, for example. And then, for me, kind of hilariously, invoked Star Trek, particularly Data and his misadventures in artistic endeavors, and in particular his poem about his cat. And she said basically that while that the poetry is an example of simulated creativity, though impressive, lacks the human spark required for genuine artistic creation. And so that being even more human-like and creative still would not apply, because Data, in today's definition, and there was a whole episode in Star Trek about the Doctor creating a holo novel and whether or not he actually owned the intellectual property around it. This is something that's been in sci-fi forever. We're living in it now, and the courts are basically saying that if the claimant is entirely the computer, then the works cannot be copyrighted. If a human being was involved in the creation, then it changes. In particular, he listed the computer system as the only author. I truly believe he was testing the limits of the law here, possibly trying to invoke the Doctor from Voyager, and testing what current limits would be. And seems like those limits are pretty hard and fast. Everybody up the chain has agreed. It's definitely an interesting situation. We've talked about it even last week about, what Altman saying that if copyright holds, then we're screwed, or something like that. So we're bumping up against the walls of the box of what copyright are right now, Evan.
Yeah, well, it seems to me there's an easy out for this, though. Like, why can't he, who's going to know? Couldn't he claim that he made the art?
So he could claim that he made the system, and therefore he is part of the creation, and therefore could have listed himself as one of the artists and could have gotten it copyrighted. But I don't think he cares about actually copyrighting this piece of art. I don't think he's worried about whether or not people can reproduce this image. I think he was literally testing the bounds of copyright law,
Right.
which is why
I
he
get
didn't
that.
list himself.
I
But
get that.
yes,
I guess what I'm saying.
100%, if you were to list yourself as the artist or even as a co-artist, no problem in copywriting it.
Right. So who's policing that? Right. So
Copyright
I
office
make
right
an
now.
image use. Right. But how do they like? So for real, right? Like, let's say I want to copyright an image. I go and I generate it 100% in with an image generator, whether that's
Mm-hmm.
Midjourney or it's Bing Image Creator or
Mm-hmm.
whatever. I then
God forbid
use
Grok.
that, right, and then use that image somewhere, and then I sue someone who hasn't. I sue someone who's taken the image
Mm-hmm.
and used it on their own site, right? Um, the burden, like, the burden is on them to prove that I didn't make it, right?
Mm-hmm.
So, like,
Yeah.
you like a lot of things look AI generated, but
Right.
like you,
There, there's a
the
certain
burden,
color palette, right, that that oftentimes screams AI from certain
right?
systems. There,
But but
but
the burden is on the burden is on the um, is on the defendant,
mm-hmm.
I think, to prove that I didn't. Because, I mean, people generally don't copyright work by submitting it to the Copyright Office.
Right.
Usually, you can just have a copyright for doing something. Uh, so then you can go out and sue someone who's taken it without your permission. And then the
Right.
question is, like, are they going to fight you in court? If they fight you in court, um, what's the claim going to be? Can they claim fair use? Things like that.
Right.
Um, so the claim here would be, hey, that image isn't real. It's that image wasn't made by a person, so you
Mm-hmm.
couldn't copyright it in the first place. Um, Now, the question then becomes, and we may see this case in the law, right? Like, I say I made this image, you have to prove that that it's AI generated
Right.
in order to beat my copyright claim.
Right. Which
How do you
which is
which
chaos.
I think which I think like I don't think the burden I could be wrong, but I don't think the burden is on me to show that I created it. I think the burden is on them to show that I didn't create it.
I think you're right.
So so that's an interesting question. Now, the other thing the other thing that's going to happen here is we're going to have lots and lots of trademark lawsuits because people generating things with AI, it containing trademarked stuff. So it's not that the image itself is the expression is copyrighted, but maybe the character or the person or whatever, you know. I tell what's the name of that audio tool? I tell
Mm-hmm.
that supposedly that is supposedly been trained on all kinds of albums.
Yep.
I tell it to create something and it sounds a little bit too much like Taylor Swift and she wants to sue me, right? So I think we're going to see a lot of lawsuits like that. And I don't think that using AI is going to save you. Like, will you be able to say, for example, hey, I went to this? I'm trying to think, what is the name of that service? I think now they just add it to Prime or Spotify, where it'll generate songs for you.
I can't remember. Marlo was talking
Suno,
about.
Su-
Yeah, I would say Marlo was talking about this
Suno,
during off camera during CES.
Suno. So I mean, it's not the only one, but Suno is well known, and Suno apparently there have been a lot of studies showing that Suno appears to have been trained on real albums. So, do you think that if you make a song in Suno, you put it out and you try to make money off of it, and then the owner of a similar song comes out and sues you, do you think saying I used Suno to generate this will get you out of the lawsuit? I feel like no,
I feel like no.
right? So
Yeah.
you're taking a huge risk because I don't think that Suno or any of these other AI generators, whether they're generating music or text or an image, are indemnifying you against claims, right?
Hmm.
I
So,
mean, think about
so it's interesting. I mostly because I think it's Inception funny. I asked Copilot in the U.S. who has the burden of proof in a copyright suit, and the plaintiff must prove two key elements: ownership of a valid copyright and copying of protected elements. So you have to prove as the plaintiff that you have a valid copyright. And so I then further clarified, what if I generated an image with using AI and then sued even though it's not copyrightable? It says the burden of proof would still rest primarily with you as the plaintiff. You would need to prove that the image is eligible for copyright protection. If the defendant argues that the image is not copyrightable because it's entirely AI generated, they may also be required to present evidence to support their claim. So, yes, the burden of proof does lie. If you're trying to argue that it's AI generated and therefore can't be copyrighted, if I generate it and I sue you, the burden of proof does legally fall to you to say it's not copyrightable because it's AI and here's my proof, which is a massive undertaking.
right. I mean, think about the lawsuit against Robin Thicke with blurred lines sounding
Mm-hmm.
too much like "Got to Give It Up" from Marvin Gaye, right?
Yeah.
So, like, that's such a subtle thing, and they
Yeah.
won, right? So, how the music industry is able to do this? How do you think it's going to play out when you make your song? Maybe you don't even know
Right.
what it was stolen from.
Right. Yeah. So I did a. I don't think we talked about this last week. So I did a class on uh, AI in content creation, and I talked about the tools that you and I talk about, right? Like my favorite tool in the world, Swell, um, and closed loop content versus open content, right? And one of the things I said was, if you're using these publicly trained, publicly used systems, you could potentially be opening yourself up to legal liability for copyright infringement because I can guarantee what was it called? Suno?
Suno, yeah.
Suno's not going to step in and go, "Oh, our bad. Yeah, we did steal that. Here's your settlement." They're going to go, "No, we didn't do that." That was him.
Right. Suno said that this is from last year. Suno said admits it was trained on essentially all music files on the internet. It said
All
anything
music
publicly
files,
available.
which means, which means, uh, YouTube.
Right.
Yeah. Which means all of the music videos from whatever that company is, Vero or Vimo, or if somebody knows what I'm talking about, please put it in the chat. But um, yeah, if they ingested all of that, yeah, all of a sudden now you're potentially in trouble.
Yeah. Right. So who's in trouble? Who's in trouble? Suno or you? If
I
you make
mean,
the song, you.
yeah, that's the thing. If you ask it to do it and it does it, you asked it to do it. If you take it and then use it for something, you took that content. Yeah. If you're pulled over with a stolen phone in your car, even though you bought it from somebody, it's not going to keep you out of trouble. Now, if you
Right.
can prove that you bought it from somebody, it might lessen the trouble you're in, but it's not gonna. Yeah, ignorance is not a defense in court.
Yep.
So, yeah, it's all dangerous. We talked a little bit ago about the dangers of screwing up, Google business listings and stuff. It's not great. None of it's good. There's lots of danger there, and as a user of the internet, you should always be aware that the little notification at the top of Copilot that says, "Oh, it's not there once you've asked questions." That's even better. Before you ask a question, Copilot says, "I may make mistakes. Please be careful." But apparently, once you start talking to it, it goes away, which is the best. Totally on brand. But yeah, that's not good enough. That's not going to keep them out of trouble, because if I get sued, they're going to get sued too, right? It's not going to. They're going to come after me because I'm the one that created the music. But if I say I used Suno, guess who's getting added to the lawsuit? Because there's pockets to go after. You're not going to get anything out of me. You might get the microphone and the computer we're talking about upgrading, but you're not going to get a whole lot out of me. But you're going to get something out of Suno. So, but having that on your public history, it's not as bad as ChatGPT or Gemini or whoever it is lying about you and your kids, but it's certainly not great. Hello, YouTube. Thanks for watching, and I hope you enjoyed this episode of F5 Live Refreshing Technology. If you did, please subscribe to the channel down below, and of course hit the notification bell, because we know that subscriptions don't mean much on YouTube anymore. If you've got topics that you'd like us to talk about in the future, please comment them down below. And if you'd like to not follow us on YouTube, there's lots of ways that you can follow along with our content by going to PLUGHITZlive.com/subscribe. There you'll see all of our shows and all of the ways that you can watch, listen, and follow along.